applications, my lord. One, PS case number has been wrongly recorded in the order, and in all the four applications, the petitioner, who is the wife of the principal accused, has been mentioned as sister of the principal. Chapter.
Lordship, may I permit to mention one matter?
Huh?
Lordship, I'm saying that I
Are legally?
filed the appeal without certified copy, Your Lordship.
No.
The Lordship, the matter is returnable tomorrow, Your Lordship. Mentioning for inclusions in the list under the heading bail in connection with appeal. That appellant was?
Was it rejected earlier?
No.
You don't know. Find out and mention.
No, sir. It was not rejected. It was not rejected.
Permitted to mention the practice for extension of interim order, my lord. Group 8 appeals, my lord. Now the requisition is.
Well, yesterday, my lord, I made a mistake. 67 to 70 was analogous. My lord, 67 was called for. My lord, I was under impression 70 will be called for. My lord, I missed. Well, I was standing, but bail in connection with appeal, my lord, let it be.
Oh, no. Whatever order is there is there.
My lord, only out of this. But let it be included then. Let it be included.
Was it rejected earlier? Then we are not entertaining it.
Your Lordship, may I be permitted to mention one matter for inclusion for hearing of appeal? Macho.
Call the list.
Matter bail in connection with appeal.
Was it rejected earlier?
It was admitted, my lord.
Yes. Call the list.
Number 1.
Lordship will kindly fix the matter for hearing. There's a stay granted, Lordship.
Stay is continuing.
Stay is continuing till today.
So we extend the stay. Affidavits, etc. Affidavits are
No, my lord, I am the writ petitioner respondent, my lord. I intend to file an affidavit in opposition, my lord. Kindly grant me some time, my lord, to
let
file.
the affidavits be filed.
Yes.
Right.
Lordships.
And after vacation, we will fix up the matter.
Lords.
So affidavit in opposition be filed within 3 weeks. Reply 1 week thereafter.
That will be vacation, Lordship, 1 week after vacation.
All right. Then within 4 weeks, affidavit in opposition. Reply 1 week after vacation. Matter will come up for hearing 2 weeks after vacation.
Lords.
Giving a date, then we will find whether the affidavit is complete. Then we start the hearing. Interim order granted earlier is extended to 31st of January 2025. Or until further orders, whichever is early. Next.
Oblate.
And this was supposed to appear on 5th December.
Correct. Commissioner of Police, Barashat Commissioner, instead of SP. Next. No. Office report. Reduced office. Yes. Name of the advocate representing the state we read as far as this.
My lord, 8, my lord, I am for the petitioner. 1031 of BNSS was not added in the cost type. In petition, I have stated.
First title be amended and section 1031.
এখানে আছে আপনাদের ওই উপরিং পার্ট পিটিশনে ইজ দেয়ার মাই লর্ড বাট ইন অর্ডারিং পার্ট
I know. Nine.
My lord, I am for the petitioner.
Petitioner has paid 50% of the bill.
এখানে আছে বিহার 2 লাখ। Called for a report. Oh. Malad had the occasion to hear the victim lady on the last occasion.
Yes, Enos.
Malad, I was only, Malad, this related to a incident which started from 2015 onwards, purportedly. Now, she claims that in 2015, she tried to commit suicide due to those sexual assault, but she survived. And thereafter, it continued till 2023, September 2023. And then she thereafter lodged the complaint in January 2024. My lord, I had annexed the documents with regard to her medical treatment in 2015, my lord, which perhaps does not support or is not consistent with what has been alleged in the FIR. Now, I had also annexed the documents which reflect that I had continued to provide for her education during the entire period. And after her
2015 document.
my lord, that we have annexed at page 41.
Right.
Malad, the further documents with regard to her education, we have also annexed that your lordship will find from page 21 onwards.
That you were
providing for her educational expenses. And after class 12, she also graduated from Loreto House. Page 21 onwards are the educational expenses.
No, what page 67 that you have annexed
My lord.
is the polytechnic where she is getting or proposed to be admitted in 2023 December. You say that
No, this is her, this is where she was to get admitted in
you
Canada.
are saying that she requested for funding.
Funds I was unable to.
Question is, does the email or any communication indicate the request for funds?
For her,
What
her,
you have annexed at 67 is just a brochure,
I understand.
just a brochure. Your contention is this brochure was sent to you, and there was a request that you should fund her education abroad. Is it evident from the trail of mails between you and her?
My lord, that I need to take instruction. I'm sorry, my lord. Yeah, we should have come back with that.
No, because your pleading
I
is
understand.
this, and the annexure is only a brochure. Now, it may be that the request is made orally, but is there a trail of mails endorsing this or supporting this?
আছে কি জানো?
So what's the
আরে
communication?
ছেলেটা কোথায়? গায়েব করছো?
আসলে WhatsApp conversation
My lord,
তো সেটা এখন certainty নেই যে সেটার মধ্যে exactly কি হচ্ছে কিন্তু there were vesicles of it.
my lord, I need to take instructions and come back if your lordship so permits.
No, that is all right. Yes, Miss.
My lord, I've just received the
You look
brief
into the
yesterday,
things.
and I have had a chance to have a chat with the victim. My lord, I have two submissions to me. One is that there seems to be an assertion that the petitioner paid for all cost educational expenses. Now, the fact is that, and this is an undisputed fact, that the victim was in the custody while she was a minor, and beyond that, in the custody of the petitioner and his and her mother. So, and the mother in this case is an illiterate woman. So there is a vulnerability associated with this, and she was, of course, she was in the custody as a ward, and she was so the financial aspect of the education, whatever has been supplied, has been furnished here, was very well taken care of. That does not mean that that's in some way absolves the charge.
We are here considering a pre-arrest bail application.
Indeed.
Whether we need to put this person behind bars at this stage. Here is a situation where a continued predation on a stepdaughter is alleged belatedly. The thing is, there are documents which show that there was care and concern. We agree with you that mere care and concern does not mean that the oppressive allegations were wholly absent. However, there are also indications in the FIR of assertions which are not contemporaneously supported. Firstly, between she says that she held back the relationship between her and rather the activities of this petitioner on her from her mother, and this caused depression and made her consume tablets and all, and she was hospitalized. The hospitalization papers show the dispute was actually between the mother and the daughter. And the dispute, mother and the daughter, therefore, does not fit into the nature and the trend of accusations made as of now. This is where we need to trash this out, and this requires to be laid on evidence. The second is the continued period for which the situation prevails. and thereafter she moves out with her partner, and there is another fight with the mother. That is the reason why we felt to make a deeper probe into the request that she may have made with regard to her funding for going abroad. If that is so, the association, if any, between the petitioner's predation and the victim had stopped since October 2023, right? If still then, sometimes in December, January, she reverts back to the petitioner and asks for funding, therefore a continued association, the confidence in the petitioner
It's not complete.
does not appear to have been impaired, even when the control over her has ceased. So these are relevant factors to be taken into consideration in these circumstances.
May I try to assist this board? In para 17, there is, I'm just trying to understand the relationship between the petitioner, his wife, who is the mother of the complainant.
Right.
It appears that in the first two GDs which have been entered, informing that the daughter has left home of her own volition, I've been informed by the de facto complainant that those letters, the complaints have been written by the petitioner himself. The signature is that of the mother because the mother is an illiterate woman. So I think that strengthens the contention that the mother was very much in the custody of the petitioner. Besides, para 17, my lord, there is an averment that the mother of the de facto complainant, this is page 9, that the mother of the de facto complainant suddenly started calling him up and making incoherent statement, pursuant to which he files a GD. So we do not know what incoherent statement is being averred to, but my understanding is, my instructions are that on 17, on that day, the 17th January, the de facto complainant called up her mother, and there was an altercation, and there she mentioned that the nature of the allegations, and where the mother confronted the petitioner, this is what happens. This is the result of the confrontation. So there seems to be prima facie a case of something amiss.
That is at page 68. K.
Annexure G is
G.
the general diary given by you.
G.
29th October 2002.
এটাই তো मतलब the complaint is
Yes,
at
we'll
page
see.
50.
Page 49.
Yes, 49 is
What
the endorsement.
complaint given on 2910,
मतलब 50, page 50.
page 50.
50.
That's by the mother of the victim.
That is, the daughter has been missing, but annexure K is page 68, and only the DD entry is
because we didn't have it.
has been annexed, not the complaint.
You didn't have.
Yes, see.
Then kindly see page 51.
The 58 is the incident where there is this heated exchange between the three of them. And it is
Page 68, my lord, annexure K. This corresponds to para 17.
right, the mother calling up. Mother calling up.
Yes. 167.
Mother calling up.
We would find, we had filed the report on an.
That is what we are saying. This is the situation. In the 164 statement, she had stated about this incident. And in this incident, she said that there was a video, an audio recording of the. So we asked the state to get the mobile phone of the petitioner and produce before us the audio recording. The audio recording has got no insinuation against the petitioner with regard to abuse. It is more in the nature of a fight between the mother and the daughter. Where is the transcript
of that audio?
You said that there was a recording.
Flash drive, I think.
Correct, but then there is a transcript of what
Part of that.
Okay, that's it. Locally transcript. Put in.
what we intend to see is, madam, two things. This is a continued allegation of sexual abuse of a minor who was in control and custody. So that degree of sensitivity has to be applied. At the same time, when we examine the allegations, attending circumstances, and the probability of alternate truths have to be kept in mind. In doing that, the statement before the hospital, etc., giving a different picture and the possibility of conflict between the mother and the daughter rather than the state of mind due to predation appears to be at variance. This is with regard to the continued relationship up to 15, 16. Then there is due care taken, which, if not completely obliterating, would also be a relevant consideration. Finally, is the assertion of agency by a child who is growing up, which again creates a conflict and the girl moving out of the residence. Thereafter, two events are being portrayed before us. First is the event of her being called to the residence and the exchange between the mother, daughter, and this petitioner. This is an unguarded and virgin extent where the possibility of either imputation in different and embellishment do not arise. It's a and in that exchange, there is no whisper of any abuse by the petitioner, by the daughter. The exchange, as we understand, which Ms. Sinha had gone to, and we will ask her to both of you view the etc. If necessary, we'll view it, but we would like a transcript to be placed before us. Right. If that is not there, and there is also a continued confidence in the petitioner even after his domain of control has waned. We have to take into consideration as additional materials to judge the existence of a prima facie case. The test being of a much higher standard, even in compared to other cases, because of the bar of 483,
438.
2 or
438, 4.
482, 2.
Yes.
482, 2
Echo.
of
Yes.
PNA.
Echo.
So these are things, Mr. Ganguly,
So far as the submission that the petitioner had taken care of the child, all the medical expenses, education. Lordship kindly reconsider the 161 statement of the mother. Perhaps it was the mother's money that was being used. She had handed over 35 lakhs.
that is all right, but the 35 lakhs could have gone in his pocket. What we would say that
Yes, that's true.
he-
But it was her money that was being
35
used
lakh.
for her daughter. That's
where is the money of the mother?
he said.
Madam, this is now a question of trail of funds. Huh? Ipse dixits don't help. What? How did she hand it? Was it her cash?
Appreciate what her profession was.
We understand that. We understand that.
35 lakhs. Why?
It is in cash or something.
Which was handed over to the.
আর আমার সমস্ত পেমেন্ট ব্যাংকে মায়ের ক্যাশ নিয়ে ব্যাংকে ফেলে তারপরে টাকা দিচ্ছি মাথা খারাপ হয়ে যায়। সব দেখছি ব্যাংকে
কোথায় পাচ্ছিস?
এই অনলাইন বিডি ইন্টারন্যাশনাল অনলাইনে পে হয়েছে
This thing we do not
ক্রেডিট কার্ড
find it difficult, particularly because of the medical reports that the mother was not privy. But it is possible that the mother was also overwhelmed because of the petition.
Can we see the earlier 161 statement of the victim also what she has to say about her mother? Like even when she diverts these facts to her mother. My lord, page 7. Page 7 is the mother, page 6 is the victim.
That we are seeing. This version is varying with the version in the 164. See this portion. See this portion and the 164. I don't know. You understand? Here she says that the mother connived, or mother said that you are misunderstanding the behavior. In 164 it is, I did not at all communicate to the mother, and because I held it within myself, I committed suicide.
This is more reasonable with her version.
Now question is, if two versions are varying with one another, we are conscious of the presumption of law. But if your intrinsic quality of the material that you produce itself is on shaky foundation, will the presumption be a construct to support a prosecution case? The ingredients come from basic primary facts. Primary facts need to be consistent. And on them, the edifice or whatever support of the presumption rests. Can't just go into the, let us say someone says, I was violated out because my mother was a person not educated or having social moorings, I kept quiet. We understand if it is consistent. We don't understand that he told the mother. Mother said, okay, you are misreading him. And in F-164, you say, I didn't tell the mother and because of depression. So this is a dichotomy which creates confusion. Now, on which presumption, on which the presumption will, the basic fact must be considered. If the basic fact is prevaricating, will that be washed away by presumption? As of now, what we do is if you can, you produce any material. We don't see from your statement or anything that there was a request for funding. Someone she may have been proud to say that I have got admitted here. But where does it say that I want some money? Please help me with money.
Except the oral demand, I cannot say it is by way of email because she forwards this.
She can forward it. Just forwarding something, will it make a demand probable?
Unless she confirms, it's an offer of admission. She has to pay the money and confirm.
Mr. Ganguly,
I appreciate
just
what is
consider normal course of human conduct. The way we are saying, if violation was so deeply ingrained in her psyche and mind, the spat that took place in December, there would be references to that. There is no reference, we give you that benefit. Similarly, we would like to, when someone, let us say, I want a funding from you. I say, this is my, please see that I can get admission notes. There should be a trail exchange.
I understand.
There
If
must
it
be
is
a
there in
trail
the
mail
WhatsApp
or
or something, I will just
communication
I'll try
with
because
regard to discussion on fund.
I don't have the phone with me now. I have to your lordship can ask the IO also to see after this date.
You please produce whatever WhatsApp exchanges between
The relationship was good.
and let it
So
be
bank can
circulated
afford
between the parties.
that.
Right.
You know, the income tax.
That will show if the WhatsApp exchanges, these are private communication, encrypted communication, the guards have fallen. And you will find exchanges much nearer truth. Okay. Her learned senior HON'BLE. Noted. Next.
Petitioner has been arrested, not pressing.
Petitioner has been arrested. Accordingly, the application is not pressed. Next.
Further statement.
Further statement of the victim is recorded. The statement is exonerative. Exonerative in view of the aforesaid exonerative. It shows there was
My lord, I am the petitioner led by Mr. Nolan, FIR under section 376, 406, 417 and 506. There was a delay of 77 days in the launching of the FIR and the victim has denied medical examination.
yes, yes. Tomorrow. Give a copy. Next.
That which is the lordship. Oh, that IP
address now regarding distribution of this.
Yes. What? IP address not being found. Does he know what is IP? Why say first question to KPD police station? Why section 67, 67A was not added? No, what now? Why not first? Why when the FIR speaks of indecent pictures being uploaded, then why are you recording an FIR under other provisions of law? Why? What is the explanation for that? Who is the KPD police station? He's the cyber crime OC. Ask him what is a hash value. মানে হ্যাঁ হ্যাশ ভ্যালু কিভাবে হ্যাশ ভ্যালু বের করা হয় হ্যাশ ক্যালকুলেটর দিয়ে তো আপনাদের কাছে আইপি অ্যাড্রেস খুঁজে পাওয়ার মতো ফেসিলিটি নেই তাহলে কেন রেকর্ড পাওয়া যাবে না একটা যে সময় ছিল তখন তো মোবাইল নম্বর ছিল তাহলে তাহলে পাওয়া যায় কিনা মানে হ্যাঁ তাতে আইপি অ্যাড্রেস পেয়েছে তো এবার আইপি অ্যাড্রেসে ওরা ওই যে আসামি তার মোবাইল ডিভাইস গুলোর আইএমইআই নাম্বার দেখেছেন তার সঙ্গে আইপি অ্যাড্রেস ম্যাচ করছে আসামিকে ধরা যায়নি কি আসামির মোবাইল ফোন তো দেওয়া হয়েছে আসামি তো বেল পেয়েছে আমার কথা হচ্ছে আসামি এসটিআর দিয়ে কি হবে এসটিআর দিয়ে তো কিছু পাওয়া যাবে না এসটিআর দিয়ে কি পাবেন আপনি আজকে আইপি অ্যাড্রেস তো আইএমইআই নাম্বার থেকে পাবেন তো আজকে একটা আসামি প্রথম তো আপনি সেকশন 67 অ্যাড করলেন না লোকটা জামিন নিয়ে নিল এবার লোক যখন জামিন নিয়ে নিল আপনি বলছেন আসামিকে পাওয়া যায়নি আপনি তো আসামিকে ডাকেননি হ্যাঁ তাহলে আসামি কি 41 আসামি জামিন দিচ্ছে তারপরে আপনার কাছে আসামি পাওয়া যায়নি এটা হতে পারে একটা আসামি যখন জামিনে আছে তার তো আপনার পুরো কন্ট্রোলে আছে তাতে কি হয়েছে মুরুটিয়া থানায় রেপ কেস হয়েছে মানেই আপনি আসামিকে দেখলেই অ্যারেস্ট করবেন তা তো না আপনি যখন জামিন নিল লোকটা তারপরে আপনি কি এফার্ট নিলেন ওকে ইন্টারোগেট করার আপনি তো জানলেন যে জামিন নিয়ে নিয়েছে আমার তো প্রথম আপনাকে প্রশ্ন যে আপনি একটা সাইবার স্টেশনের অফিসার ইনচার্জ আর আপনি আইটি অ্যাক্টের অফেন্স অ্যাড করেন না মানে কাকে মাফ করব স্যার কাকে মাফ করব মাফ করে লাভ কি হবে আপনার পুলিশ স্টেশন তো একটা সাধারণ পুলিশ স্টেশনের থেকেও খারাপ ভাবে চলছে কি লাভ হবে বলুন আপনি যে ভাবে চালাচ্ছেন যে ইম্পর্টেন্স দিচ্ছেন এই মামলাগুলো যে কোনো সাধারণ পুলিশ স্টেশনেও এইভাবেই চলবে তাহলে আর মানে সিগনিফিকেন্ট ডিফারেন্সটা কি নাম বদল করে তো লাভ নেই, কাজে তার প্রতিফলন চাই, কাজে তো কোনো প্রতিফলনই নেই। ওনার ওনার মোবাইল ফোনটি মুরুটিয়া পুলিশ স্টেশনে জমা পড়েছে। আপনি কি জানেন আপনার যিনি সতীর্থ পেছনে দাঁড়িয়ে আছেন তার কাস্টাডিতে ওনার মোবাইল ফোন আছে? জানেন কি কি না? আপনি কোথাকার ওসি? মুরুটিয়ার ওসি doesn't know that the mobile phone has been handed over by him.
That is what they are. That is, I victim not of the
The accused mobile phone has not been handed over. Mobile phone of the victim girl, what would it show? The question of obscene photograph privately communicated is not the issue. The question is who uploaded it on the social media site. That your KPD officer is saying that it is from a SIM card which has now been deactivated. We asked him that the IP address will match with the electronic device, if not the SIM card. Taito. So if that is the case, then the most important piece of investigation is his electronic device. The brilliant officer has not found time or necessity to collect the device from the accused who is on bail. So he has obtained bail, that's brilliant. But even if he obtains bail, investigation doesn't stop. The first thing which the officer, at least we expected a cybercrime police station leader to know, that in cyber offense detection, arrest is really irrelevant. He just he needs custody of the devices and analysis of devices. If he doesn't do it, we cannot force him because we are not his masters. We only see the pitiable investigational efforts because we need to judge the guilt of a person. He is helping us to do it, and we see the help that we get. He doesn't add section 67. Accused is on bail. He does not make any effort to get his device. He says, I gave notice. What will we say? If he changes his mobile phone, how will you control him? The first thing you do when you do a cyber investigation is take control of the devices that he has dominion. He may use his friend's device. Their local investigation necessary. That yes, the friend handed over, he had control dominion, and there are two things. See the latitude, longitude on that day. See the IMEI number, match it with IP address. See the latitude, longitude of the device and say that friend's residence is X, his residence is Y. At that time, the mobile device is at Y. This is how you investigate. Do you require arrest for that? But our police officers are only trained. Investigation begins with arrest, it ends with bail. As soon as bail is granted, investigation is ended. Because my fun and games of depriving liberty of citizen is lost. Then the hard work begins. I don't do the hard work. I am the threat. I will deprive you liberty. Training of police is one of the first and foremost things. He has technical knowledge, but he doesn't have the functional perceptions of investigation, because he is trained in investigating through 19th century and 20th century methods, not the 21st century methods. That is what he is trained in. He knows the lathi. He doesn't know the internet. So what will we do? What will we do with these officers? Hand over the mobile phone. Take custody of the mobile phone, add 67, pray for cancellation of bail in that case. Officers in charge of has been added. So what? Has he prayed for cancellation? Now you have to advise him on Pradeep Ram. Pradeep Ram says a new offense, police must pray for arrest before the judge. So he should do that. That we can excuse him, it should be the public prosecutor advising. But we cannot excuse him from not adding 67. We cannot excuse him not from taking dominion and control of the devices. These are all his lapses, and his superior should look into it. And we would prefer him being transferred from this post. He doesn't have the mindset to investigate offenses. The mindset should be completely different from investigating offenses through collection of physical evidence. Digital evidence collection is, you just require a device and access to other devices to investigate cybercrime. Like the way you have the sweatshops of cyber hacking unknown in a small place and which can create tremors through the world. A police officer well equipped can send tremors through the minds of offenders just in a small cubbyhole if he has that mindset and training. But our officers don't have it. Officers in charge of Murutia and KPT police station are present. Being queried, officer সাইবার শব্দটা শুধু পুলিশ স্টেশনটাকে নামাঙ্কিত করার জন্য নয়, ওটার যাতে রিয়ালিটিতে থাকে সেটা দেখাচ্ছে। কটা আপনাদের ওখানে সফটওয়্যার আছে ফর অ্যানালিসিস? শুধু একটা। আর কটা আপনার দরকার? ওগুলো আপনার ডিরেক্টর জেনারেলের রিপোর্ট থেকে আমি দেখব কি 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 সফটওয়্যার চাই এবং কোন কোন পুলিশ স্টেশনের কটা সফটওয়্যার চাই। এইভাবে করলে চলবে না। আজকে 90% মামলায় ডিজিটাল এভিডেন্স অ্যানালাইজ করতে হবে, শুধু আইটি অ্যাক্টের অফেন্সে নয়, মার্ডার কেসেও করতে হবে। কটা লোক এখন চিঠি লেখে? মোবাইল ফোনে কি করছেন আপনারা? সিডিআর কালেক্ট করছেন, টাওয়ার লোকেশন থেকে দেখছেন। আপনারা কেন ল্যাটিটিউড লংটিটিউড দেখছেন না? ল্যাটিটিউড লংটিটিউডটা পাওয়া যাচ্ছে না। সিডিআর এ যেগুলি প্লেস করছে শুধু যেটা পাওয়া যাচ্ছে হচ্ছে টাওয়ার লোকেশন। এইবার তারপরে আপনাকে সেটা থেকে, ঠিক বলছেন আপনি, ওখান থেকে মাইন করলে ল্যাটিটিউড লংটিটিউডটা পাওয়া যাবে। সেইটা কোনো ইনভেস্টিগেটর করে না। তাহলে তো আপনি এক্সাক্ট লোকেশনটা পেয়ে যাবেন। কারেক্ট, আইপিতে তো লং ল্যাট দেবেই। লং ল্যাট দেয় আইপি অ্যাড্রেস থেকেই তো আপনি বুঝে যাবেন ওটা কোন এক্স্যাক্টলি কোন জিও লোকেশন থেকে ইন্টারনেটে উঠলো, কোন 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 সার্ভার দিয়ে অ্যাক্সেস হচ্ছে। আজকে আপনি এখানে হোঁচট খাচ্ছেন, আর ক্রিমিনালরা কোথায় চলে গেছে? সার্ভার মাস্ক করে দিচ্ছে, যেখানে আইপি অ্যাড্রেসেও আপনি খুঁজে পাবেন। সেই জন্যই তো বলছি ভিপিএন ইউজ করলে পাওয়া যাবে না। সেই সেই কথাটাই তো আপনাকে বলছি। আপনি তো আইপি অ্যাড্রেস যেখানে এক্সপোজড আছে কি এক্সপোজড আছে না সেটাই ইনভেস্টিগেট করছেন না। তারপরে তো আপনাকে ভিপিএন করলে কিভাবে ট্র্যাক করতে হবে সেটা বানাতে হবে। এখানে আপনাকে কি অ্যাপ্লাই করতে হবে? ট্র্যাডিশনাল ইনভেস্টিগেশন মেথড। ডিরেক্ট এভিডেন্স নেই, তখন কি করবেন? সার্কামস্ট্যান্সিয়াল এভিডেন্স দেখতে হবে। ডিজিটাল ট্রাফিক ফ্লো দেখতে হবে, প্যাকেজগুলোর হ্যাশ ভ্যালু দেখতে হবে, তার সঙ্গে পর্নোগ্রাফিক হ্যাশ ভ্যালু মেলাতে হবে। পার্টলি হ্যাক করলে ওই ফাইল নাম্বার বা ফাইল নেম গুলোর সাথে কানেক্ট করতে হবে, সিমিলার ফাইল নেম ফাইল নাম্বার। এগুলো তো আপনাকে কেস স্টাডি হিসেবে ডেভেলপ করতে হবে এই কালচার। সাইবার ক্রাইমের পুলিশ স্টেশনের ওসি হওয়ার অনেক ডিফিকাল্টি আছে, হবেন না। এমনি পুলিশ স্টেশনে থাকুন না, শুধু লাঠি আর 161 খুব সুন্দর জিনিস, কিন্তু এর বাইরে চলে গেলে ওগুলি কোনো কাজে দেবে না এখন। After 2 weeks, let's see what conscience does. We want result in this case. Next.
To, my lord, no allegation of physical relationship.
What is your age?
21.
Appellant submits that there was a romantic relationship between two young persons Statement of the victim also supports this version. In spite of notice, nobody appears for the victim. Victim has already been recovered. Under such circumstances, we are inclined to grant anticipatory bail. Next.
Lordship, I am appealing for the petition. Lordship,
Yes.
Lordship, co-accused persons were granted anticipatory bail by your Lordship. There is a typographical error in the earlier order. That is why earlier file has been tagged. Petitioners are standing on the same footing.
Has crept into order dated so and so. The word দেখো কি লেখা হয়েছে person is the principal
Not
is not the
is the principal accused assailant. It was written. It will be not principal assailant.
In the first line of the order we read as learned counsel for the petitioner surgery as per FIR they are not the principal assailants. Other
Not the principal.
Petitioners stand on the same footing who have been এটা যাচ্ছে 18 এ যে অর্ডারটা দিলাম petitioners stand on the same footing with এই যে কুমার 18 এর কথা বলিনি লিখে দিলে দেখো petitioners stand on the same footing with co-accused who have been granted anticipatory bail accordingly we are inclined to express.
Grateful, Lords.
About 70 years in the father-in-law. Because the husband and the mother-in-law were arrested. They were
Yes, what is the material again? We have considered the materials on record. Petitioner is the father-in-law. He is a
$326, 511, there is an existing dispute and regarding a court.
statement.
They are the female accused before.
All right. Petitioner are the female accused. Allegation of attempt to rape are not leveled.
Here were three have been enlarged on date. Articles have been articles have been recovered from them. It is the Shakti, season list. The petitioner's name.
Offense.
Wildlife.
Wildlife. What did you?
Nothing of this side. My name was transferred from when they
What?
principal were in custody.
Turtles. You are smuggling turtles.
My name was transferred while they were in custody.
Maybe.
From
Who is this petitioner?
this petition is
Taposh Boshak. So what is the complicity of Taposh?
Then your lordship in the
I think we are asking the state. What is so why you gave notice? That is why we are asking. What is his complicity? From where are we getting it? Export of tortoise? Earlier said in the market to sell tortoise meat. I have eaten tortoise. It's cartilage, yes, because where is Taposh? He's just saying Taposh is has a house beside. Hmm. We saw that. Where is Taposh's role? Correct. Taposh gave money. Then have you got money trail? Have you got money trail? Money flowing to them? How are we saying money? Petitioner submits that the white card. Your investigation is going on. All right. Are
My lord, at the time of commission of offence, the victim was 16 years old. My lord, slightly higher than section.
What the 164 says.
And the boy was 20.
All this will not do. What the 164 says. Does it say there is a
Stay of 1 year, 4 months. They sit together for 1 year, 4 months.
I'm from for the petitioner. Petitioner number 2 is the wife of the petitioner number 1. There is already a family dispute
এটার পরে উঠবো
existing, a civil dispute between them because the criminal case was lodged against.
We have considered the materials on record. There is pending, there
Offense under section 108 BNS and section 35 of BNS. The petitioner is the mother-in-law. The instant case has been lodged after a delay of 7 days. The FIR is after a delay of 7 days. And the crime accused has been granted bail. Crime accused has been granted bail.
Allegation under section 109, that is 307, over the issue of distribution of paternal property, fight between among the.
আমি এটা করে দিচ্ছি স্যার
The FIR was from the section 106. The item below lordship, and this by for petitioner and the consent that the petitioner but the asset tax component had paid 30 lakhs in lieu of 2 lakhs in the name that lordship the petitioner had already registered 1 lakh in the name of the tax component.
All other it's not an issue. Last agreement, the agreement for construction. My lord, my lord, spoke at the land, but there is no money. My lord, thereafter, money.
I for the Manoj Sharkey submitted over the issue of filing the initiative of the agricultural and altercation field. And offense under section 307, 376, 511, victim and revenue for medical examination. But victim refused for medical examination.
আর আমরা বইখানে যাবি না পাই আমার কাছে সব প্রমাণ আছে
Lord, I'm for the petitioner, my lord.
My lord,
The
just
allegation-
now. My lord, just now I have informed that
My lord,
have been
two ways.
informed by de facto complainant about the existence of this case. My lord, police has informed her at 10 a.m. today. My lord, kindly give me liberty to file over wakalatnama tomorrow.
81, 105, my lord, road traffic accident, my lord.
And 304 of the earlier act.
Yes, yes. My lord, there was a road traffic accident. Even the petitioner had sustained injuries, was at.
My lord, I am for the petitioner. Petitioner is arrested, my lord.
My lord, may I please. My lord, 323A, 118, 109, 3 of the BNS, my lord, along with my lord, 25, 27 Arms Act, my lord. Allegation is that, my lord, the person entered into the house due to their previous enmity, my lord, fired.
Husband of the victim lady. The children are with him, lordship. The victim lady is asked for the children, so the petitioner number 1 along with his associates entered through the terrace and shot her. lordship.
Yes, yes, this is the allegation, my lord. My lord, kindly see the others, my lord.
29
My lord, in respect of others, my lord, though no involvement is there.
former husband, divorced, but the children with him, and the husband got married again.
My application, my lord. My lord, preliminary 360, 376, 64 of PNS, my lord. my lord, long-standing relation, father
Not
and the
long-standing relation. State,
Fa-
state.
my lord,
Not today.
my lord, may I pray one thing, my lord?
Service
I have
is
served, but that's not completed.
All right, officer in charge shall notify the victim with regard to pendency of proceeding and her right to legal representation through High Court Legal Services Committee. Matter will appear 1 week hence.
Grateful, my lord.
Please, 1 week notice, Ms. Khan.
My lord, may I file the affidavit of service, my
Yes.
lord?
Next.
Affidavit of service, my lord. Then move. Grateful. It accepts.
Alarm for the petitioner, my lord.
My lord, although no recovery, investigation is going on, telephonic
The
communication
principal accused is on statutory.
We have considered the materials on
and
record.
antecedent, my lord.
Complicity of petitioner in dealing in narcotics has transpired from statement of co-accused, telephonic exchanges between the petitioner and co-accused from whom narcotics was recovered, as well as his criminal antecedents. Investigation is in progress and custodial interrogation is necessary to reveal evidence with regard to the complicity of the petitioner in the crime. Next.
But I am for the petitioner, item number 33, my lord. My lord, case under section 447, 326, 307.
You have not come to court?
My lord,
Huh?
due to the personal reason, my lord.
Personal reason.
My lord, there is a case and counter case, my lord.
Lordship, statement of the injured.
What is the nature of injury?
Simple injury,
We have
Lordship.
considered the materials on record.
Warrant
Case
of
and
police is
counter
pending.
case were registered. Injury on the victim is simple. Accordingly, we are inclined to grant answer.
Deeply obliged. Deeply obliged.
Excuse me.
34, my lord, I am for the state.
My lord, I am for the petition. My lord, allegation under section 302 and 120B of the Indian Penal Code. As per the allegation, the principal has aliens one Shima Mondol and one Toton Sheikh. Man, kindly seize my.
My lord, the mobile phone of the deceased and the bicycle has also been recovered from the house of. Yes, yes. Yes, yes, my lord. All are there. All are there.
Look, 35 I am for the petitioner, but 31 item number could not appear for the state. Hello, the 406, 408, 409, 467. Milord, the petitioner, Milord, is the assistant service manager, Milord, of a company called Lindgao Mobiles India, Milord, which Milord deals with the service, Milord, of Oppo brand of mobile phones. Milord, the entire allegation, Milord, is against Milord, the one Shubhopriyo Haldar, Milord, who is the area service manager. Milord, if your lordship will see the FIR as well as the charge sheet, Milord, the entire allegation is, Milord, against Shubhopriyo Haldar, who being the head, Milord, had Milord siphoned funds, Milord, and also Milord made certain mismatches in the stock. Shubhomoy was arrested and granted bail. Milord, there was mismatched, and the entire blame is on Shubhomoy. He was arrested, subsequently granted bail.
Anand Kesri.
And the investigation revealed that not a single amount was, Milord, came to my account. There are other accused persons who received, Milord, the usufructs of crime, Milord. And the entire documents have been seized, Milord. The recoveries took place from the house of Shubhomoy. Shubhopriyo, Milord.
My lord, I am Shayan Adhikari. Joystree rejected. Your lordship will see the order of rejection of Joystree, my lord. Data copy. My lord, sorry, my lord, my copy is marked. Specific. Yes, that was the reason given for rejecting her by the coordinate division bench.
Yes,
Lord.
yes.
Order sheet. Order sheet.
May it please, Lord. My lord. My lord, there is something which is illegible. My lord, we have typed it. The search which was made by CBI on the 4th of May 2023. My lord, that have, but it's illegible, my lord, you will see.
আমি বলে দিচ্ছি আপনার ছোট ভাই আপনি দরজা
My lord, certain dates are very important. The RC case 6, in which I am being sought to be produced, my lord, it was initiated on 9th of June 2022. My lord, the ECIR in which I am in custody, my lord, that was registered on 24th of June 2022. My lord, CBI called, my lord, RC was 9th of June, prior to it. 9th, and this is 24th June. Now, my lord, I was called by the CBI and I attended the office. My lord, we have not got the certified copies, we got the server copies. Right?
Second server copy.
And second, my lord, we noted it down, brought it, my lord, subject to corrections. It is for the application.
These are our applications before the session is good.
এই কপি দিয়ে একটা আমাকে আমার কাছে কপি নেই না না হ্যাঁ no yeah don't be sure no no Malad, please read it Malad. Well, which part Malad? Malad, the prayer is for the production part, through virtual part. The IO inspector, that part, Malad. I have perused the prayer of the IO and the materials in the case diary. The court is satisfied about the materials the IO has recently collected during investigation, prima facie disclosing the involvement of the UTP. The IO inspector so submits before the court that the investigation reached a crucial point where the interrogation of the above two persons in CBI custody, after showing him arrested, seems to be essential in the interest of investigation of such a large-scale scam pertaining to so-and-so. Having considered the prayer, in the light of the prayer available, this court is inclined to allow the prayer. Thereafter, my lord, thereafter, my lord, thereafter. So that can't be done, my lord. My lord, your lordship sees 267. My lord, please sees 263. The next day's orders, my lord. No, my lord, please, my lord, please. Please, please. Malad,
23.
For us, it's passed. If the order.
Malad, if a shown arrest order is passed, then I have to be produced within 24 hours. I have not been produced in 24 hours. Whether that would tantamount to illegal detention then? That is what I'm trying to say. So I'm in illegal detention. No, I'm not saying that. But what I'm trying to say.
Is a relevant consideration in a prayer for every arrest. Once the arrest is done,
the arrest has not been shown. But what is arrest?
The arrest is an order of the court.
The arrest, my lord, is my lord reading of the order.
Please kindly ever dekhiye this.
Yes, I give a lot. Just up. Paragraph 54. No, production warrant, my lord. My lord, it's a question of shown arrest. My lord, shown arrest is not there in the court. Shown arrest is not there in the court.
So, how about the court? How about the
my lord, please see the next day's order.
How about the collection order?
See the next day's order, man. My lord, Justice Kant, my lord.
Prayer was not.
Sorry, my lord, I'll give another copy. Sorry. I have a copy now. My lord. My lord.
My lord, I have got a copy.
Oh, it's that page?
To consider.
Well, there he has said specifically that he has not been arrested unless the production is done.
Consider. 20.
Well, that's true. But that's true, Malad. So my right to come for anti-Semitic. No, well, then let me say something, Malad, which will be part of the order. So your lordship, rightly or wrong, my lordship is hearing my application for anti-Semitic. Well, see the next day's order, my lord. He is not arrested in production.
The judge does not know what he is right to do. In his earlier order, he has already said that he is allowed to prayer
for production warrant.
Correct.
Not production warrant can be for a witness also, my lord. Your warrant can be for a witness also. No, my lord, what I am trying to say. My lord, 267. My lord, 267. Yes, man, I'll just give it to you. CBI code, my lord, CBI and ED code.
20 big note.
That is what I'm saying, mother. Well, that is not 267, my lord, with due respect. Well, 301. See 301. Well, see 301, 2. The word arrest is not there, man. Confined or detained. No, but I can't. He's not arrested me, so I can't be going in custody in connection with the new case of CBI. That is what I'm trying to say. Well, see 301. It's 302, my lord. Well, I heard a new word yesterday, my lord. PTW. PTW. The Supreme Court judgment which I showed to you, lordship, my lord. Prisoner transfer warrant. That is actually the yes, my lord. That is what I was seeing. Well, Justice Padriwala has given a judgment that even if I'm arrested in connection with the case, I'm in custody. My right for anti-Semitic bill doesn't go away. So he has said that, my lord. So now, my lord,
PW has been issued. As soon as the PPW is issued,
well, can it the cart before the horse? Well, a cart before the horse.
If the Supreme Court judgment, if the Supreme Court says PPW is issued, then it goes away. The PPW has been issued here, rightly and wrongly. If it is wrongly issued, set it aside.
No, 26 is in my favor. Well, order dated 26. No, no. Why should I? But I don't want. No, but I don't want to.
He has lost sight of the earlier order. You understand? Earlier order, he can refer to assess the in a but once the
Well, Lordship, give me that direct,
you are saying the answer. Once
well, para 54, man.
Yes.
There, my justice, sorry. I'm sorry, my lord.
And then for that.
Right, man. Tomorrow I'll come back.
Should not do. Others can do. You are leader of the path. Huh? Why one of these done? Because
No, man, two. I got your lordship. Man, your lordship, I've appreciated.
we don't want to prejudice your right because let us say we also decide on very extensive charge. Whether it's 25 block, if you wish, there is a production warrant right wrong. You are taking advantage of subsequent order, we will clarify.
Right.
Once the order is passed, you cannot.
Go back to his honor. Right, man, right.
Let's say I have not issued once he has issued.
No, man. But I'll just find that out. But if I can find that out, man,
If you want to challenge the production,
I get your lordship, man. I get it.
production was that is what was only on our mind.
Yes.
Because we have that
Idea in view. Yeah.
but we are completely general and our understanding of the ratio is this. Just because a person is in custody and a second case is registered, he doesn't use the right of approaching the
Court for AB. For AB.
obtaining a production warrant under 301.
Yes.
If he gets some clearance, then that may be best to put the charge.
Who will take me into custody and guard me? Yes, available one. As for 438.3. Yes. Yes, sir. Yes. You're right, sir. So, Lavan, give me 1 day's time, please.
Have a production warrant, a question of.
Of showing. No, may I ask your lordship, this also one. Supposing the word was production, for argument's sake, the arrest part was not there by the IO. Then even can it be deemed to be that it is arrest? I get it, lordship. Well, let me answer that tomorrow, man, if I could get an answer. Or I will concede, man. Or I'll concede. 3 and 2. Oh, same. I get your lordship. Now I understood. So once you issue a production warrant, they deemed that I am in custody. Yeah, in the new case. That is just a managing. Yes.
Now under
22 Constitution. Yes. Well, tomorrow. Tomorrow. Well, I'll do it tomorrow.
You take advantage of that.
Yes. That I have no answer to that. No, I got your lordship. I got your lordship. Now, Maran, let us understand this. Now, we are now on a hybrid mode. Now, when the hybrid mode, my lord, I'll tell you what happened, my lord. In the case of Partho Chatterjee, one of the same thing happened, and the court accepted it through video. He did it.
I understand why. So that is what is giving me to wonder
Why it was not done.
why the subsequent order makes an impression at the production order. It makes a sense of resistance.
Forgetting what he had written on 25th.
Here, on as the person Basically, attendance is something like asking a water, a glass to be full when it is empty. Is a paradox.
Correct.
What is the use of a production word?
Yes, he's appeared.
So why should production warrant be necessary when the man is physically before me? The production warrant is a process to physically
From custody in another case.
development of technology. Since the judgment of the sun, clearance has been understood.
Has even surrendered. Out. That way.
This now is to verify the clearance.
Yes.
That physical appearance can
Also be done through virtual mode.
And we are online and pass appropriate orders or demand.
Whatever.
Where you could argue that the person was available to get never arrested, what was the trigger?
Why all of a sudden?
The serial arrest, extend detention through collateral proceedings.
Yes, sir. Absolutely. My lord, there is one other thing. Well, may I tell you, Lordship? According to me, subject to my lord, 1.5 years. 30th of May.
Now,
No, it is
of delay. Now let us jump into the box. So this is Mr. Trivedi and Mr.
What is this advice? Mala, there is one thing. Mala, there is another thing in this matter, Mala. Mala, subject to corrections by Mr. Trivedi. Mala, when the first charge sheet has been filed,
justification तो होना चाहिए. When your material surface, I am. Your material surface 6 months at home, and went on mulling over.
What is crossing my lord's mind, my lord, we will satisfy if it comes to that particular level. That's why, my lord, I am not opening my mouth. Less.
I'll tell Lordship. No, tomorrow. Or withdraw it. Oh, my lord, but another thing, my lord, subject to my learned friend, my lord, my personal feeling is charge sheet was filed under IPC sections. Whether the special judge has power to take anything. So once the public servants chapter goes away, PC Act goes away, would they pass any order? True. But I am not a public servant. Nobody is a public servant who has been made an accused in this case. Nobody. No. Malana, what has happened? Well, first charge sheet. Wait. I'll tell you. Malana. I get it. That in a different forum. I go by the. Well, let's sleep over it. Tomorrow I'll come. I get your lordship. I don't know, but I appreciate it. I'm grateful for your lordship. So, my lord, give me just 1 day's time. Because your lordship must be knowing the pressure I have on me. So, my lord, I may be a fraud. So, they may bring up big lawyers. So, my lord, I leave it to your lordship. Only 1 day. Justice Kant will not take me otherwise, my lord. I did not want to neglect your lordship. Sorry, my lord. Sorry.
My lord.
Yes. My lord, I am but the affiliate engaged by your lordship for the above legal.
37.
37.
Piru Murmu.
Pirumuru.
You are there, Mr. Mundol?
Well, yes, I am engaged by legal aid authority.
He is the legal aid. The legal aid was not there, so new legal aid came.
No, perhaps he is appearing behalf of the state. He appeared.
Because you did not appear the earlier occasion.
No.
Yes. We have passed order.
Yes, sir. কালকে
Bidu.
কালকে কি অ্যাপিয়ার করেছো?
কালকে হয়েছে।
ও
কালকে আমাকে বলেছিল না।
তাহলে কালকে মিস করে
Yes, then
নেই কোর্ট সে দিয়ে নেব।
tell us.
Yes, my lord, I am languishing in jail more than 10 years. The arrested
The
on
hearing
July.
appeal finally. No bail.
My lord, only based on the PW 11, PW 11 and 12. They are the, my lord, eyewitness. If you lordship believe this 11 and 12.
Why?
then, my
Apart,
lord,
even if we don't believe, there is enough evidence.
no, there is there
Circumstantial evidence.
circumstantial evidence totally, my lord, extrajudicial confession before the police authority. Yes, my lord, otherwise, my lord, except my lord 10 and 11, there is no evidence.
We'll tell you.
PW9.
PW9 and 10.
Your lordship,
PW9 and 10.
last
First, motive.
Yes.
There is motive evident from quarrels which are stated by PWs 13, 14, 16 and 17.
And the own brother of the appellant, your lordship.
And PW5 father also saying about quarrels. Then 9 and 10 say that 3 days before on 13 they saw you and this person a lady going out. PW10 says that you were seen coming out of the field.
Alone.
And then on your leading statement, the boulder and your shirt is recovered from the place of occurrence. With all this and the postmortem report. Now, if we discount 11, 12, these are circumstances against you.
My lord, kindly go through the evidence of, my lord, that
We want to go
witness.
through with you.
But kindly fix it.
Next week, we keep it not today, not this week. Not this week. This will be in the list. As soon as we take it up, we'll hear out. We make ready. Prepare a chart of the circumstance, why you are saying they are improbable, and we will hear you. Not this week. Heard Mr. Mundal and Ms. Khan?
Yes.
Matter, we are not inclined, paper books are ready, and sentence is one of life imprisonment. Hence, we have taken up the matter for final hearing. Heard Mr. Mundal and Ms. Khan. Matter is fixed for further hearing. Next. Yes, next matter.
I'm for that. My lord, 302 life punishment. 4%, my lord, they were, my lord, attended trial. Now, my lord, this petitioner has been convicted. One samad expired, other two acquitted. Now, my lord, 13 witnesses. My lord, let me place the FIR first, my lord. Kindly have a look. একটাই তো কপি আছে আমাদের কাছে, আর কপি নেই না, একটাই দিন। Well, I'm sorry, my lord, this is one certified
You
copy.
didn't take the paper book from the court?
It's ready, my lord, I do not know.
You didn't know it was being fixed.
But I'm
brilliant.
Then, my lord, let me collect the paper book.
Sir.
My lord. Now, my lord, allegation is that, my lord, let me read the FIR. আমার বিনীত নিবেদন এই যে, this is the father of the deceased. আমি কাতিরউদ্দিন শেখ, বয়স 70 বছর, such and such, on 20th 5/2009 তারিখে আপনাকে জানাইতেছি যে রাত 8টা নাগাদ আমার বড় ছেলে জাইমুদ্দিন শেখ, বয়স 45, such and such, রাস্তার ধারে নেফাজউদ্দিন শেখের টালির ছানি দরমা বেড়া বৈঠকখানায় বসে গল্প করছিল। গ্রামের মেম্বার আতিবুর মন্ডল, ডাক্তার সোনা, ইয়ামিন কাজী, সাম শেখ।
Atibur is PW?
Atibur is PW, lord. Anwar and Yamin are PWs. Atibur is not been examined. Yamin is PW, lord, 5.
5.
And Anwar is PW 8.
All right.
না my lord, হঠাৎ 8-9 জন লোক সেখানে সশস্ত্র অবস্থায় আমার ছেলে জাইমুদ্দিনকে আক্রমণ করে এবং তাদের হাতে থাকা আগ্নেয় অস্ত্র দিয়ে আমার ছেলেকে পরপর গুলি করে। আমার ছেলে লুটিয়ে পড়ে। গুলির আওয়াজ শুনে আমি সেখানে দৌড়ে যাই এবং দেখি যে আমার ছেলে বৈঠকখানায় পড়ে আছে। আততায়ীরা হাতে বন্দুক নিয়ে দৌড়ে চলে যাচ্ছে, তাদের মুখ কালো কাপড়ে ঢাকা। ওদের মধ্যে 2 জন আমাকে দেখে উত্তেজিতভাবে গালিগালাজ দিয়ে বলে যে তোর বেটাকে আমরাই শেষ করেছি। লাইটের আলোয় ওই 2 জনের মুখের কাপড় তুলে আমি যখন খিস্তি করছিল তাদের চিনতে পেরেছি। তাদের নাম নেফাজউদ্দিন এবং সামাদ। উভয়ের বাড়ি চটকাশিকালী তেহট্ট। এরা উভয়ে আমার চাচাতো ভাই। ঘটনার পরে পরে লোকজন জড়ো হয় এবং খুনিরা পালিয়ে যায় পূর্ব দিকের মাঠ দিয়ে। অন্যদেরকে পরে দেখলে চিনতে পারবো। লোকজন আমার ছেলেকে মরে থাকতে দেখেছে। আপনাকে জানাচ্ছি যে খুনি নেফাজউদ্দিনের সঙ্গে আমার ছেলে আইমুদ্দিনের পূর্ব রাগ ও শত্রুতা ছিল। তার ফলে নেফাজউদ্দিন ও সামেদ দলবল নিয়ে আমার ছেলেকে খুন করে। So, my lord, the incident took place at the Boitokhana, my lord, the living room of this petitioner, where my lord 5 and 6 other persons were sitting and they were gossiping. This is the case of the prosecution. Now, my lord, in this case, 13 persons were examined. My lord, the 2 persons, those who were sitting over there, that is
5 and 8.
5 and 8, my lord, they turned hostile. And my lord, only except PW6, who is the brother of the deceased, my lord, his version is similar to PW1. My lord, both of them allegedly they were sitting in a culvert around 20 cubits away from the place of occurrence. And my lord, after that firing of the sound of the firing, they came to the spot and they found that 2 persons are going out along with other persons. Now, my lord, they are known persons. Earlier, there are enmity that is evident in the FIR. Now, my lord, this bullet and or my lord, neither the charge and or conviction has been made under section 25-27 Arms Act. Now, my lord, the no arms has been recovered. My lord, the ammunitions, it has, my lord, the bullets, sale of bullets which has been seized in course of investigation has not been sent for expert opinion. My lord, no doctor has been examined. Now, my lord, my lord, the PO has been shifted with regard to the statement of PW6. My lord, PW6 stated that the incident took place inside the house of this petitioner. And one person, Nefajuddin. And my lord, one person said the PO is the club room. One person said. But my lord, in the sketch map, first of all, my lord, and another thing is that my lord, the body was lying in the courtyard of the, my lord, the complainant, that is the father. But my lord, in the sketch map, there is no house of the father, and on how after within 2 months, 2 my lord, hour at the time of my lord, making Surothal report, how the body has been sent to the that place, that is my lord, missing, everything missing, my lord.
That has been explained in. Are we hearing a bail application, Mr. Bitashok Banerjee? Why are you standing up? You don't have a chair.
No, sorry. It's okay.
My lord, IO has never sent any sought for any expert comment, expert opinion. My lord, there are few injuries. My lord, it has been stated that there was indiscriminate fire by 8-9 persons by the complainant. And my lord, here the injuries are কোথায় গেল? আমাদের কাছে ইনজুরি রিপোর্ট ছিল না? ভাই ইনজুরিটা গেল কোথায়? আমার এখানে তো ছিল
50.
না? হুম, হুম, হুম।
15 of evidence. Hey, order. That page 15.
না, না, আমি দেখলাম তো ইনজুরিটা গেল কোথায়?
That page 15 of that.
Yes, ma'am. Bleeding from nose and mouth with the dried up, one penetrating injury in front of left ear, just medical injury measuring half in brain deep. Around injury, there are burning of blackened along with seeing of hair and dressing of wound. Exit left parietal bone with lacerated margin. One penetrating injury on the left forearm and one shoulder joint injury. One penetrating wound, transverse fracture, scapula fracture on the first 4 ribs, left lung puncture, heart puncture, right lung puncture. One metallic bullet recovered from the right side of the chest of the cavity. So, one bullet has been recovered. But the case of the prosecution was when they were gossiping together, indiscriminately 8-9% they started firing. So, the origin of the FIR with regard to the allegation and roping this petitioner is doubtful. Now, my lord, it has been stated by the complainant that he has seen the identified the witnesses and or seen the my lord, accused person in the light of the that bulb light. Now, my lord, other witnesses like PW2, he categorically stated that there is no street lamp post in our village at the time of incident. Now, with regard to the evidence of PW3, my lord, he stated that previously there was a grudge in between Samad and Zaimuddin. Samad is dead. Samad has also been murdered. Now, my lord, in the murder case of Samad, this PW6 is an accused. That is the brother of the deceased.
This happened after the murder of this man. Murder of this brother.
That should be.
Samad was murdered after.
Yes, after. Initially, Samad was charge sheeted.
Then Samad during trial was.
During trial, Samad murdered.
He decided that judges cannot be relied. PW6 felt judges cannot be relied. So let us take it.
Whatever steps I
Our
take.
justice delivery system is this. You get my brother, I get you.
So this man who identified this petitioner, my lord, he was aged about 80 years at that point of time. And there was no light. This is the case of the defense, my lord. He admittedly, my lord, he was sitting 20 cubic feet away. So, my lord, nobody has seen out of those 8-9% who fired the deceased. And that part is also there that Surothal has been held in the house of this complainant.
That we have seen.
Yes, mal.
Yes. Yes, now Mr. Bitashok.
Regarding the eyewitness of the incident, that is the complainant is the eyewitness of the incident, he named these two persons. And regarding the place of inquest, my lord, that has been explained, my lord. Kindly see page 14 of the judgment, my lord. PW 13 is the SI Habibur Rahman. Second last paragraph, my lord.
Yes. You can't read. You cannot read.
There was a missing link. How dead body of Josimuddin Sheikh reached to their courtyard, that is the courtyard of PW1. Although he was murdered in the Boitakkhana of Nafajuddin.
I find from the inquest report and the evidence of the PW 13 that the dead body of the Josimuddin Sheikh was brought to his house, that is courtyard of the PW 1, where inquest was held.
Who said? I find from the evidence of
PW 13.
PW 13.
That is the SI Habibur Rahman.
Habibur Rahman, how you will say?
He is the first IO, my lord.
Where has he said? Have you seen? Oh, you don't have the
That I have the copy of the. Page 14 of the judgment.
See the first part. See the evidence is there.
Evidence.
Part 1, part 1. There is no FSL report. So take the appellant, uh, uh, appeal is ready for hearing.
41 on this one. 41 and on this one.
And 39, 40? 39? Not today? Not today. Fine. Detail.